In this video, we're going to talk about 11 million immigrants in the United States who do not have a lawful status for purposes of immigration or are considered undocumented. So we will understand how to get a green card as an undocumented immigrant in the United States.
Visit our Swat&Vee channel with your questions to see how best we can help you out with your process. Please don't forget to subscribe if you're new to the channel.
For the purposes of immigration, there are 11 million people in the United States who do not have a lawful status. According to the responses provided by immigration specialists, there are many questions that are asked regularly by these individuals. We have to be aware of the fact that acquiring a lawful status is a very difficult process that is highly dependent on the specifics of each individual situation. It is highly recommended that you speak with an immigration lawyer. The majority of the questions raised in that video will be addressed in today's lesson. Question number 1. Who is considered to be an immigrant without proper documentation? Although the term undocumented is frequently used to refer to individuals who entered the country illegally, many visa holder categories, such as F1 visa, academic student, and B1, B2 visas, visitors, tourists, for example, can be considered undocumented once their document expires and they have continued to reside, overstay, in the United States of America. Question number 2. What are the steps involved in submitting an application for lawful status, whether it be temporary or permanent? There are many routes that one might pursue in order to gain a legal status, and each route will be different based on the conditions that are relevant to the immigrant in question. Additionally, there are types that are permanent and temporary. There are, however, certain categories that are more rapid. Consultation with an immigration attorney is the most efficient approach to determine which of the available categories will best meet your requirements. It is possible to submit an application through marriage to a U.S. citizen or lawful permanent resident, LPR, through the petition of a relative who is a citizen of the United States or an LPR, and even through work if certain conditions are met. In addition, there is a category called Victims of Domestic Violence, VAWA, a category called Victims of Other Criminal Activities, U-Visa, and a category called T-Status for Victims of Trafficking. In addition, there are unique classifications for people who are born in various nations. When undocumented persons come to visit us or ask us questions, we listen to their stories and do our best to link them with family members who may already be in the country. Therefore, we make an effort to find ways to obtain green cards through familial links. He went on to say that there are numerous routes that a person can take to qualify for a lawful status in the country, whether it be permanent or temporary. Question number 3. Does it matter how someone enters the country? The process of getting residency can be complicated by the manner in which an individual enters the nation. Those who are currently present in the United States and have been granted admission or parole are eligible to submit an adjustment of status application. If a person does not have a record of having been paroled or allowed to the United States, they will likely be required to leave the country and show themselves at a U.S. consulate located outside the nation. The third question are people who are leaving the country subject to arrest or detention for their illicit entry into the country. When a person leaves the nation, they will all be required to go through security checkpoints, where a Transportation Security Administration (TSA) officer will examine their passport. Those travelers who do not have a visa stamped on their passports, which indicates that they are undocumented or have overstayed their visa, may be pulled to the side by a Customs and Border Protection (CBP) officer who will decide whether they will be detained or removed from the country. When you are near a border, your rights are almost always limited in some way. When they try to leave, there is a slim chance that they may be detained. If there is a warrant out for your arrest, you run the risk of being taken into custody. Even if you overstayed your visa, it is unlikely that you will be imprisoned. However, your departure will be recorded electronically in a number of different ways. According to Lenny B. Benson, Distinguished Chaired Professor of Immigration and Human Rights Law at New York Law School, while the United States does not have a formal exit visa requirement, the government does collect data from airline manifests and entry swipes of passports in the next country. This is despite the fact that the United States does not have a statutory exit visa requirement. In the event that you decide to leave, the 3 or 10-year bar will also be activated. It is advised that you have your attorney present it to Immigration and Customs Enforcement, ICE, as soon as possible, if you are traveling out of the country and are held at the airport. But, if you have a continuing adjustment of status, it is best to have your attorney present it to Immigration and Customs Enforcement, ICE, as soon as possible. Questions number 4. Is there a time limit within which I must apply for a green card? The amount of time it takes to process an application is another variable that may shift. According to Benson, the process for obtaining visas based on a marriage, for example, can depend on 2 different components. First, is the category under which you are applying for immigration subject to a quota limit? There are several types of immigration for which there are no waiting periods, such as marrying a citizen of the United States. You may be subject to quota delays if you get married to a lawful permanent resident or have a derived immigration status because your spouse is immigrating through a family or job sponsor. To summarize, there is no clear answer to the question of how an undocumented immigrant can fix their status, nor is there an estimate of how long the process would take. This is because, unless Congress passes a law similar to the Immigration Reform and Control Act of 1986, IRCA, which granted amnesty to millions of eligible immigrants who had been in the United States for a certain period of time, there is no way to determine how long the process would take. Questions number 5. How can individuals who have accumulated unlawful presence avoid having their ability to visit the United States of America suspended for a period of 10 years? Individuals who have lived in the United States past the expiration date of their approved stay by the Department of Homeland Security, DHS, for example, overstaying your tourist visa, will be considered to have accumulated unlawful presence according to Immigration Code 212A-9-BE. This provision may be found in Section 212. Those who have accumulated 180 days or more of unauthorized presence in the United States but have been here for less than a year will have their entry into the country denied for a period of 3 years. Those who have accumulated a total of more than 365 days, or 1 year, will have their accounts terminated for a period of 10 years. It is possible for a person to be prevented from leaving the nation for a variety of reasons, as was the case at the beginning of the epidemic when airports were forced to close. However, in order to ensure that your future travel plans are not put in peril, the USCIS would typically request that you obtain a visa extension. In the event that you overstayed your visa, will you be subject to arrest when you make an attempt to exit the country? Even if you overstay your visa, it is unlikely that you would be detained. However, your departure will be electronically documented in a number of different ways. If your overstay was brief, excusable, explainable, etc., you may find that you are still able to apply for and acquire a visa stamp to return as a tourist or other temporary category. This is the case if Benson mentioned that there is also a bar that is always open inside the statute. Questions number 6. What exactly is a permanent bar? When a person who is not permitted to enter the country, for instance, having been forbidden for 10 years, enters the country without being inspected again, they risk receiving a lifelong ban. There is a form known as the I-485, which is an application for authorization to reapply for admission into the United States after deportation or removal. This form acts as a sort of authorization to reapply after removal. Question number 7. What are the exceptions to the 10-year ban and the 3-year ban? There are 2 sections that contain waivers for the 3-year and 10-year prohibitions, respectively. Waiver for a return to the United States in the capacity of a non-immigrant. This waiver is only valid for a short-term return. It is one of the most lenient exemptions in the entire law, but the procedure has to be carried out precisely as described, and it may take some time. You will be required to provide evidence that supports the claim that your intended stay in the country is only temporary. Waiver as an immigrant. This section provides for a waiver of the bars if your spouse or parent is a lawful permanent resident, holder of a green card, or U.S. citizen. Waiver as a refugee. This part allows for a waiver of the bars. Having children who are already citizens of the United States is a factor, but it is not necessary. Question number 8. Is it possible for an undocumented immigrant to seek for a visa that allows them to work while they are already in the United States? Benson stated that there is not a singular or straightforward response to this question. He went on to say that some people qualify to seek a non-immigrant visa with work authorization. For example, a person who is nationals of a country where we have a treaty of investment and/or trade. Some individuals can be eligible based on a unique provision of temporary protected status, sometimes known as TPS. Everyone has a different set of circumstances. Thus, it is important to get specialized legal assistance. Before an individual can apply for some categories of employment visas in the United States, they must first obtain a sponsor who will submit an application on their behalf. They are short-term classifications, but an employer always has the option to make them permanent. People who are already present in the country have the option of applying for specific employment visas that correspond to their eligibility, talent, vocation, and other relevant factors. There are situations when national interests play a role in the decision as well. Question number 9. What should I do if I am unable to get a sponsor for the type of visa that is tied to employment? If an individual does not have a sponsor but meets the requirements for an Employment Authorization Document, EAD, under specific categories, such as the Deferred Action for Childhood Arrivals, DACA, program or the Temporary Protected Status, TPS, program, they may still be permitted to work in the United States. Individuals who fall under these categories are given the opportunity to submit a request for a work authorization while their status is still considered active. In general, the regulations that determine who is eligible for work authorization are located here. There are certain groups of people who may be eligible to apply for a work permit due to exceptional circumstances. Some examples of these groups include Afghans who have been granted parole admission, Ukrainians who have been granted parole permission, people who have been granted deferred action, and asylum seekers whose applications have been pending for the necessary amount of time. Benson emphasized that there is no all-encompassing work permit. The 11th question: are unauthorized immigrants qualified for a U visa even if they do not have any record of having entered the United States previously? The U non-immigrant visa is a non-immigrant visa that was created in conjunction with the Victims of Violence and Trafficking Act in the year 2000. This visa is intended for immigrants who have been the victims of mental and/or physical abuse and have worked with law enforcement. Incest, kidnapping, extortion, and rape are just some of the crimes that have been committed. It is necessary for individuals to submit a waiver request if they do not have a lawful status and do not have a record of being admissible but still qualify for the U status route. In order to qualify for a U visa, you must demonstrate that you have not committed a violation of the grounds for inadmissibility, and in order to be admissible, you must have a history of lawful admission. You can overcome the grounds for inadmissibility by submitting Form I-192.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!